On September 10, 2025, defendant Jeremy Taylor was arraigned in the 34th District Court in Wayne County, Michigan on a felony firearm charge in violation of Section 750.227b of the Michigan Compiled Laws and brandishing a firearm in violation of Section 750.234e. The charges stemmed from an alleged road rage incident that occurred in April of 2025, during which Mr. Taylor was accused of pointing a handgun at fellow motorist Elizabeth Worrell from an adjacent lane during the early morning commute. On October 15, 2025, a preliminary examination hearing was scheduled before Judge Brian Oakley, with Assistant Prosecutor Stephen Campbell appearing on behalf of the people and defense attorney Scott Weinberg representing Mr. Taylor to determine whether probable cause existed to bind the matter over to circuit court for trial.
Gentlemen, are we ready for appearances on Taylor? This lady's not connected with the case?
She's our witness.
Oh, you're the witness? Come on up. Come on up. Watch your step on my ramp right here. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Have a seat right there. Just make yourself comfortable. Mr. Kaplan, when you're ready.
Thank you. Good morning. State your name for us.
Elizabeth Worrell.
What do you do for work?
I work at a logistics company out in New Boston.
Taking you back in time to April 23 of this year, 2025, at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 695, coming up to my exit to get work.
What type of vehicle were you driving?
Like a Santa Stray Chevy Trailblazer.
Are you alone in the vehicle or do you have company?
No, I was like myself.
You started telling the judge about you on I-275 North. Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was typical, nighttime, right before the sun was coming up, it's about 5:30 in the morning.
Are you able to tell the judge the color of the other vehicle?
Yes.
What's the color?
It was like a dark gray, dark blue.
Are you able to inform the court the model of the vehicle?
Yeah, it was a Chevy Malibu. License plate was the first EJY.
How do you know the license plate was showing EJY?
Because as he was speeding away from me, and as I exited onto my exit to get off forward, he said past me at probably about 100 miles an hour. And I caught the first grade license plate and the description of the vehicle.
Does anything?
Yeah, I'm gonna object to the estimate of 100 miles an hour, because she actually can prove how she knows it, so.
Well, that's a lay opinion. It's really not important to the case. But under 701, that's a lay opinion issue.
Well, that's fine, it's not important why we're listening.
Because it's part of the investigation.
Let's move on.
Thank you. Anything more unusual happened while you traveled at 975 North?
When I noticed that vehicle behind me, like I said before, I had changed lanes. The vehicle followed me, and I want to say it was the 3rd time that I had changed lanes. The vehicle followed me again. I did brake check the vehicle behind me, which I know you're not supposed to do.
What happened after you brake checked?
He got to get closer. And so I had moved back into the middle lane, and he was again right behind me, even closer to the floor.
Anything happened after you changed into the middle lane?
Other than him following me, no, not until I had gotten up to closer to the exit I was getting off at.
Which exit is that?
The West Huron exit.
Anything unusual happened there near that exit?
Yeah, as after I had been followed back into the middle lane, I was just nervous at this point. So I waited until the last possible second, made sure that the lane next to me was clear, and I just booked it right off of the exit. And then that's when the vehicle pulled up next to me.
Anything happened when that vehicle pulled next to you?
I saw the outline of a handgun pointed at me.
How far were you from the person holding the handgun?
The vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm gonna walk towards you with the judge's permission. Can you stop me when I reach that distance?
Probably about right there.
Judge, may the record reflect about, I know I'm short, but about 7 feet.
Mr. Weinberg, thank you.
How certain or uncertain are you that a gun was pointed?
100% positive, I saw the outline of the handgun.
What were you thinking when the gun had been pointed at you?
That I was gonna be shot.
But what did you do, if anything? After the gun had been pointed at you?
I just got off right at that exit, and when I had looked over, the vehicle next to me had rolled the window down and pointed that gun at me. I did see the outline of the gun.
Was the gun pointed at you on one occasion or two different occasions?
Just once.
What do you do after the gun's pointed at you? Do you contact authorities in some way?
I could pull into work, contacted my wife and, let her know what happened. She told me that with.
Can't tell us what she said.
Okay.
But anyway, you contacted
So-
your wife.
Yep, I contacted my wife. I ended up leaving work and, at the end of the road that I work off of, there was a New Boston police officer.
Did you ever contact with the officer?
Yes, I pulled up next to the officer, explained what happened and asked what I do moving forward. And then that's when, he took my statement and this all began.
Are you able to identify the man with the gun?
Yeah.
Why not?
It was too dark. I couldn't see the face. The only thing I could see was the outline.
Thank you, Brandon.
Mr. Weinberg, your witness.
I'm sorry, what was your name?
Elizabeth, Laura.
Elizabeth, my name is Scott White. I'm going to ask you some questions. If you don't understand them, let me know. I'll stop it when I'll rephrase it, okay? Sir, can you stand? Sir, can you identify that man at the table? You cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection's been asked today. It's
Is that correct? You can't.
been an objection asked.
Clarification.
So you have no idea when Mr. Taylor was the man you're talking about that day, correct?
No.
And it was too dark to identify him. Is that correct? What kind of day was it?
5:30 roughly in the morning.
5:30 in the morning, so it was dark. When do you claim that he actually pulled up next to you? Was the light in his vehicle on?
No, the lights on the, other side of the freeway, that's how I could see that that's I could not see
Okay,
his face.
okay. So you didn't see a gun, you saw the outline of the gun, correct?
Right.
You can't identify the gun, correct? Can't identify the model or make, correct? You saw an outline of what you thought was a gun, correct?
Of what was gun, yes.
Well, did you ever touch that gun?
No.
And you can't identify anything other than the outline, correct?
Correct.
Have you ever seen a gun close up before?
Yes.
Do you own a gun?
No, I do not.
Okay. You ever seen the outline of a handgun like this gun before?
To me, handguns for the most part look the same.
Did you understand the question?
Yes.
My question was, did you ever see an outline of that specific gun before?
I can't answer that.
Is that a yes or no?
Objection, she said she can't.
Well, answer that.
You testified that this was a road rage type of situation, correct?
Yes.
At some point, you slammed your brakes on in front of him while you were driving, isn't that correct?
Correct.
And that would precipitate this incident, correct?
We object, she doesn't know what to say.
No.
Well, you're right.
Excuse me, we don't know what's in the mind of the other person?
That's fine, but
So that was a speculation objection?
Yeah.
Was that the first incident between you and the other vehicles when you brake checked the vehicle?
that morning, did you make a statement to the police?
Yes.
And again, did you tell them at that time that you could not identify the man or the person who allegedly pointed a gun at you?
Yes.
Okay. And did you ever tell the police that you heard this man say anything?
No.
So you can't identify his voice either, is that correct?
Correct.
You can't identify anything other than you saw the outline of what you think was a gun, correct?
Correct.
All right, I go through this.
Any follow-up?
Thank you, Ryan. No further question.
Ma'am, you can step down. Watch your step on my ramp.
On both direct and cross-examination, Ms. Worrell admits that she could not see the face of the man who pointed the gun at her, and that she only saw the outline of the gun. Under Section 766.13 of the Michigan Compiled Laws, a magistrate conducting a preliminary examination must make two distinct findings. First, that a felony has been committed, and second, that there is probable cause to believe that the defendant committed it. Ms. Worrell's limited ability to observe her assailant bears on both prongs. First, Her testimony that she saw nothing more than the outline of what she believed to be a handgun raises a question as to whether the evidence establishes that a firearm offense actually occurred. Additionally, her acknowledged inability to identify the face of the person holding the object means that her testimony alone cannot confirm Mr. Taylor as the individual who committed the act. A judge must find both that a felony was committed and that there is probable cause to believe that the defendant committed it before binding a case over to circuit court, and Ms. Worrell's testimony, standing alone, presents challenges on each.
Your Honor, we have one other witness who called him, and that's our trooper, Trooper Jonathan Meyer.
Raise your right hand. Swear or affirm till the truth, the whole truth, and nothing but the truth today.
I do, sir.
Settle in. When you're ready, Mr. Campbell.
Thank you, Your Honor. Good morning, Trooper Meyer.
Morning.
Sir, how many years have you worked with Michigan State Police?
13.
So were you working on April 23 of 2025?
Yes.
Can you tell the judge where I-275 near South Huron Road, what municipalities in that area?
New Boston
In which county?
in Wayne County.
Well, sir, did you have an opportunity to speak to a woman named Elizabeth Morrell?
I did.
She's the woman who testified a few moments.
That's right.
Why did you speak to Ms. Morrell?
That would have been on Huron Avenue, right there, just west of I-275. She had left the workplace to come to meet with us there.
Did you know Ms. Morrell before the state?
No,
How long did you speak to Ms. Morrell?
probably approximately an hour.
Can you describe her demeanor?
Shaken, frightened.
How did you become involved in this custody?
Our dispatch center was contacted by the New Boston Police Department.
How much time passed between when dispatch received information about an alleged crime on the freeway and when you met with Ms. Morrell?
I would say approximately 30 minutes.
Trooper Meyer, did you meet a man named Jeremy Taylor?
Yes.
If you saw Jeremy Taylor again, you recognize him?
Yeah,
Look around the courtroom and let us know whether you see Jeremy Taylor.
I do. Yes, sir.
What is he wearing and where is he seated?
He is seated next to the defense attorney, wearing a maroon shirt, and that's finger on his neck.
Noted.
Thank you, Your Honor. Why did you speak to Mr. Taylor?
Mr. Taylor was my suspect, the registered owner of a vehicle matching the description given by the victim.
Oh, can you provide me a license plate, partial license plate number?
That's right.
What, do you remember what that is?
It was EJY with the first three.
Who provided that to you?
Miss Laurel.
In terms of that EJY 275 partial license plate description, did you attempt to determine the owner of the vehicle?
Yes.
How did you do that?
So using our license plate reader cameras in the area, I conducted a search using the criteria provided at partial plate along with a vague vehicle description, and was able to come up with two possible matches to that.
Ultimately, you narrowed the field.
From those license plate reader camera photographs taken of that vehicle, I was able to retrieve that full license plate, run that license plate through our law enforcement information network.
And through a lien, did it identify anybody?
I did, yes.
Whom did it identify?
It was Mr. Taylor as the registered owner of that vehicle.
You know his first name?
Jeremy?
Did you make any determination as to whether Mr. Taylor, in fact, drove such a vehicle?
Yes.
And what was the vehicle? Were you able to tell us the color and model and year?
Yeah, it's a blue, I believe, 2009 Chevy Malibu.
Did you at any point advise Mr. Taylor of his brand?
I did, yes.
How did that?
A traffic stop was conducted.
By who?
I did. And I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me, rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, took him into custody.
So don't go any further.
Yes, sir.
Terms of the Miranda.
Yes,
When prizing of such rights, did you do so from your memory or from a form?
that's read to him from a form. I read it to him from a form.
Can you estimate for Judge Oakley the number of times you've read Miranda rights to suspects?
A fair estimate would be several hundred times.
Did you read some of the rights, all the rights, or none of the rights to you?
All,
How long did you speak to Mr. Taylor?
approximately an hour.
Now, after reading him his rights, did you ask whether he wished to speak to a lawyer?
I'm sorry, what was
Did
it?
you ask whether he wanted a lawyer or whether he wished to remain silent?
Yes,
What was his response?
he agreed to talk. that we avoid his rights.
Did you offer him any promises of leniency to speak to you?
No, sir.
Did you threaten him in any way?
No, sir.
Did he appear to be deprived of food, water, shelter, sustenance, or sleep?
No, sir.
During direct examination, Trooper Jonathan Meyer testifies that he advised Mr. Taylor of his Miranda rights prior to questioning, that Mr. Taylor agreed to speak with him, that no promises of leniency or threats were made, and that Mr. Taylor showed no signs of deprivation of food, water, shelter, or sleep. In the 1966 case of Miranda v. Arizona, the Supreme Court held that the Fifth Amendment privilege against self-incrimination and the Sixth Amendment right to counsel require law enforcement to inform a suspect of these constitutional rights prior to any custodial interrogation. These mandatory admonitions have come to be known as Miranda warnings, or reading a suspect their Miranda rights. Under the Miranda doctrine, any statements obtained during a custodial interrogation are inadmissible unless the prosecution can demonstrate under the totality of the circumstances that the suspect knowingly, voluntarily, and intelligently waived their Miranda rights. Promises of leniency, threats, or conditions of physical deprivation can each undermine the voluntariness of a waiver, as they suggest the suspect's decision to speak was the product of coercion rather than a free and informed choice. Mr. Campbell's questions on each of these points therefore seem to be directed at establishing that Mr. Taylor's waiver was knowing, voluntary, and intelligent, and that the statements that he made to Trooper Meyer are admissible as evidence.
Did you inquire as to where his whereabouts earlier in the day, like April 23, 2025, at about 6 in the morning?
Yes, I did.
What did he tell you his whereabouts?
He explained that he was traveling on northbound 275 on his way to work at approximately that time.
Did he indicate where he was headed, where he was coming from?
He was coming from his home and headed to his workplace in Van Buren Township.
Did you inquire about any incident that might have occurred between two vehicles?
I did.
What's the specific question you asked him?
I asked if there was any unusual road rage type incidents that had occurred then.
What did Mr. Taylor say in response?
Initially, he denied that there was, saying that something had happened the day prior.
You said initially he did.
That's right.
What does that mean?
So when I first asked that question, had anything unusual like a road rage incident happened, he said, no, not this morning. Yesterday, something happened between me and a female in a light colored vehicle.
Does he give a different answer at some point?
He does, yeah.
How does the transition occur?
I asked further questions about that incident. And I said, well, there was an allegation that something happened this morning. And then he said something along the line of, oh, maybe that was this morning. And then goes on to describe the victim's vehicle and somewhat of a road rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked him and flipped him off,
What is slipping off?
presenting her middle finger to him. Derogatory.
Did you specifically ask him whether he pointed a gun at another woman?
I did, yes.
What did he say?
He denied it.
Does he later give an explanation?
He does.
What does he say?
He said that it could have been that what she saw was him pointing his finger at her, and then later added that he may have had a coffee mug in his hand at the time he pointed this.
You indicated to the judge earlier in the direct examination, this saying he had a find it.
Yes.
Did you find it?
Yes.
Where you located it?
In the center console between the driver's and passenger seat of the vehicle.
How far is that gun from the driver? Where the driver would have been seen?
Directly next to him, within arm's reach.
The information you had been given about the vehicle, the latest vehicle, how does it match?
The first three of the license plate match, and also she described the color and model of the vehicle along with bumper stickers stretching from one tail light to the other across the
Did
back.
those coincide or not coincide with the vehicle you noticed?
Those all coincide.
What happened to the gun?
The gun was seized from the scene of a traffic stop.
Are you familiar with the term holstered gun?
Yes.
Gun being holstered?
Yes.
What does that term mean?
That means secured in a holster for carrying the firearm.
When you recovered the gun from the center console, was it holstered or unholstered?
I do not recall.
Would your report refresh your memory?
Yes,
Do you have your report with you?
I do not.
Judge, do I have permission to approach the witness and have him review his report?
Sure.
Read it yourself, Trooper Meyer.
Yes, sir.
Thank you.
Thank you.
Judge, do I have permission to retrieve the document?
You do.
Please remember the document. What is your memory tell?
That in fact, the firearm was in the center console unholstered.
Was the firearm loaded or unloaded?
It was loaded, magazine full.
If you investigated shootings in your career,
I have, yes.
tell the judge which is more readily usable, a gun that is holstered or a gun that is unholstered.
Unholstered.
Thank you, Your Honor.
Mr. Weinberg.
Supervisor Scott, I'm going to ask you some questions if you don't understand something. Yes, sir. So you were called onto the scene by other police officers. Who else was first on the scene?
That would have been two Boston police officers.
So this wasn't a car originally pulled over by a speaker.
That's correct, yes.
And when you got to the scene, where was my client?
That was unknown to me at the time we were applying for this.
Did you pull my client over?
Yes,
So when you pulled him over, you pulled him over because of this match and weight, correct?
that's correct, yeah.
Did you first approach my client's car?
I did, yes.
And was he in the driver's seat?
He was.
And he, as you testified, first told you, right when you came up, that he had a CPO, correct?
That's right.
As he was obligated to do.
That's right.
You didn't see him on the gun.
I did not see the gun at first contact.
And in no time did he provide you with the gun, correct?
He did not provide me, as in hand me the gun, no, sir.
Correct. So who actually ended up pulling the gun out of the car? Who found it?
To my recollection, I found it located.
Do you remember whether I searched and found the gun in here?
Yes. Now, I had two other troopers with me, so that's why I say to my recollection, I'm the one who pulled it out of the Senate Council.
And did you pull it out before or after you interviewed my client?
During, well, I don't remember how many questions had been asked of him prior to us removing the weapon from the vehicle.
But you had already interviewed him, correct? So,
I had spoken to him, yes, that's right.
and you read his Miranda rules.
That's right.
And at any point, did you take my client, put him in your vehicle, and start discussing this matter, interviewing him without reading his Miranda?
No, he had been read his parental rights prior to.
And you only read it once, correct?
That's right.
When you first arrived at the scene, isn't it true that you took him out of his vehicle and had him sit in your swagger, correct?
I don't recall at one, or when at the time frame he sat in my vehicle, but he did sit in my vehicle, that's right.
Is that when you read his Miranda rights, or is it after?
I don't recall.
Could you recall getting a statement from him after you read his Miranda? And do you recall your conversation when you spoke with him?
I do,
Do you involve the questions and the comments you made to him when you were interviewing him?
not every comment, no, I'm sure not.
But you remember your conversation?
Yes.
And do you recall telling him the rendition of what she had told you, or what your understanding is of what the complaint was?
Yeah.
And that there was some type of pointing of a gun at her, correct?
Right.
Do you recall telling him that there was evidence to show that he actually did point the gun at her?
Yes.
From a video camera?
That's right.
Do you have any evidence of it?
No, sir.
So you lied to him about it.
Yes, sir.
And is it your practice to lie?
Objection, he's allowed to lie.
Well, I'm asking,
He can be Pinocchio, it doesn't matter. He can say whatever he wants.
I understand that, and I agree with you, but that doesn't mean Mr. Weinberg can't ask me questions about it.
On cross-examination, Trooper Meyer acknowledges that during his interrogation of Mr. Taylor, he falsely told him that video evidence existed showing Mr. Taylor pointing a gun at Ms. Worrell, when, in fact, no such evidence existed. When Mr. Weinberg presses Trooper Meyer on this directly, Trooper Meyer confirms that he lied. Mr. Campbell objects to the line of questioning, noting that law enforcement is permitted to use deception during interrogations. Judge Oakley agrees that officers are legally allowed to lie to suspects, but overrules the objection, permitting Mr. Weinberg to continue with his questions. In the 1969 case of Fraser v. Cupp, the Supreme Court considered the implications of police deception during interrogation after officers falsely told a murder suspect that his alleged accomplice had already confessed and implicated him, prompting the suspect to make incriminating statements of his own. The court held that while the police misrepresentation was relevant to the voluntariness analysis, it was insufficient on its own to render an otherwise voluntary statement inadmissible, and that such questions must be resolved by viewing the totality of the circumstances. Under that framework, Trooper Meyer's false claim about video evidence did not automatically require the exclusion of any statements made by Mr. Taylor, but it became one relevant factor that a court would weigh when evaluating whether his decision to speak was truly knowing, voluntary, and intelligent.
so is it your practice to lie to a suspect during the investigation?
We object to that question. It doesn't matter what his practice is. It could have been the first time he lied, or he lies all the time. It's not relevant.
Relevance objection.
it's not only relevant, Your Honor, it's also goes to his experience and his practice as a trooper. The prosecutor went into excruciating detail about how many types of stops he had, whether or not he's had gun types of investigations, whether or not he loaded, how he knows is it practical to have something on his hip if it's holstered or not. I'm just going by his practice in terms of interviewing witnesses.
You're stretching, but I'll allow it.
So is it your practice to lie to a suspect while you're doing an investigation?
It's not necessarily my practice, no, sir.
But you chose to do it in this.
Yes.
Isn't it because Ms. Worrell could not identify my client? Isn't that correct?
I'm sorry, what is the?
You had told him and lied to him that there was evidence to show that he pointed the gun because she could not identify my client. Isn't that correct?
I'm struggling to understand the question.
So let me rephrase. Why did you lie to my client about the picture showing that a picture that didn't exist, showing that he pointed a gun?
Judge relevancy, it doesn't prove or disprove anything in the contrary.
Yeah, what's the relevance?
Relevance is why he was trying to get my client to admit something.
Well, I'll take judicial notice that it seems to have worked, if that helps.
Well, did it? Did he say that he agreed that he actually did point a gun?
No, sir.
So he denied it.
That's right.
At any time, before you read his Miranda rights or after you read his Miranda rights, did he ever say that he pointed a gun?
He did not.
He did say that he might have pointed his finger or a cup. Isn't that correct?
That's right.
And did you hear Ms. Worrell's testimony today?
I did.
And you,
Judge, you can't comment on another witness's testimony.
I didn't ask him to comment, I just asked him to be heard.
That's not relevant.
Besides Ms. Worrell saying she saw an outline of a gun, is there any evidence you collected showing that my client pointed a gun at Ms. Worrell?
No, sir.
Do you recall whether or not your squad car had a video on the side?
It does, yes.
And do you recall whether that recorded any of your conversation with my client in your vehicle?
Yes.
And you recall whether or not, had you reviewed that?
It has been some time. I reviewed it either that day or that week.
But it's your sworn testimony that prior to interviewing my client in that vehicle or outside the vehicle or any time that day, that you read his Miranda rights, correct?
Yes, I let him swear.
I have no further questions.
Mr. Kaplan, any redirect?
Thank you, Your Honor. Can you demonstrate for the judge, did the defendant make any gesture where he described possibly pointing his finger at the moment?
He did, yes.
Can you show the judge, stand up and show the judge the gesture of the defendant?
Yes. He said that he may have pointed his finger and did something like this.
So for the record, can we agree that the trooper has stood up and pointed his index finger with his thumb closed?
Yes, sir.
An apt description?
Nothing.
Go ahead.
Nothing.
All right, any recross? Trooper, you can step down. Watch your step on the ramp.
Your Honor, before that.
Any defense witnesses? Argument?
Judge, in this case, the witness says a gun was pointed at her. Could she be mistaken? Yes, she could be mistaken. The question is the probable cause that the gun was pointed at. She seems certain, Judge. Despite a very effective cross-examination by Mr. Weinberg, she said that was a gun. I saw the outline of the gun. I've seen guns. That was a description. Now, in terms of who the culprit is, whoever did this, Judge, allegedly did it, was driving a dark-colored Chevrolet Malibu with the first three digits of the license plate being EJ. Now, think about that, Your Honor. Think of the coincidence if he's got the right guy. I mean, somebody else driving a dark-colored Chevrolet Malibu in that area on I-275 North. Think of the likelihood of this license plate featuring EJY and it being a dark-colored Chevrolet Malibu. And he had a gun in the car. And it wasn't holstered. Now that's important. It means it's readily accessible. This was a low-grade incident that spiraled out of control, and it's very unfortunate, but fortunately, nobody was injured. And the finger? Maybe it was my finger. That's not something you forget, Judge. It wasn't as though he had been interviewed weeks later. Yeah, maybe I pointed a finger. We would ask around to find the case, so where's Judge?
Mr. Weinberg.
Thank you, Judge. Well, it can't just be, he couldn't be mistaken. This man is charged with a third felony and a mandatory 2-year felony firearm. They better have more than simply, she could be mistaken. She did not identify a gun. They had no pictures of a gun. They never identified any gun that she identified. They never had any evidence said, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun where she readily admitted it was too dark even to identify my client. It was at 5-something in the morning. There's no lights on, maybe some street lights. she has an extremely weak testimony in this matter. That someone can just drive up and say that they actually saw someone with a gun and then get them charged with this. So I disagree with this experienced prosecutor who's handled thousands of these cases that there is enough evidence to bind my client over. Maybe if they had the gun, maybe if they had, or even identify my client as the driver of the car, but they don't even have that. So I'm asking the court to dismiss this.
Go ahead.
And reviewing, this very night, but in reviewing the case, you're determining whether there's probable cause to believe the crime occurred. And there's more than probable cause here. Maybe
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over. October 29, 9 a.m. Bond will continue. Good luck downtown, gentlemen.
At the close of the preliminary examination, Judge Oakley found that the prosecution had met the probable cause standard and bound the matter over to circuit court, though he remarked from the bench that he did not see any way the prosecution would obtain a conviction. The case was subsequently transferred to the Third Circuit Court in Wayne County, where it was assigned to Judge Shannon Walker. On December 17, 2025, Mr. Taylor entered a plea of nolo contendere to the charge of brandishing a firearm in public, and the felony firearm charge was dismissed. Judge Walker sentenced Mr. Taylor to 2 years of probation, 160 hours of community service, and court costs and fees. This hearing highlights the gap that can exist between what the law permits and what the public might expect from those sworn to uphold it. Trooper Meyer's admission that he lied to Mr. Taylor during interrogation may strike many as fundamentally at odds with the expectations that we place on law enforcement, and yet this false statement was entirely permissible under the existing legal framework. The law draws the line not at honesty, but at coercion. And as long as a suspect's waiver of his rights remains, quote-unquote, knowing, voluntary, and intelligent under the totality of the circumstances, the fact that an officer deliberately lied to a suspect is subject to far less scrutiny than many citizens might assume. The permission to deceive suspects reflects a deliberate policy choice, one premised on the idea that dishonesty in service of investigation is meaningfully distinct from coercing an involuntary confession, though where exactly that line falls has never been a question with a clean or universally satisfying answer. What the law permits and what feels moral and just to the majority of everyday citizens do not always converge, and police interrogation